Hello viewers and students. This is Dr.K.S.Neharkar and I welcome you in my YouTube channel at lecture series on labor laws first. Friends, in this lecture we are going to discuss the concept where when the strike and lockout becomes illegal. Friends, we are going to discuss this concept in two parts. In first part, we are going to discuss the prohibition of strike and lockout under section 22 and 23, and after this lecture there will be another lecture on the same part, that is when strike becomes illegal under section 24. So friends, firstly we are going to discuss the first part of this lecture, that is section 22 and 23 of the act. Friends, as we know, the strike and lockout, these are the practices that are generally adopted in industry. These are adopted to pressurize each other by employer and employees. So regarding right to strike, see, right to strike and lockout is not recognized as a right in India. So regarding right to strike, there is a famous decision of court, that is in T.K. Rangarajan versus State of Tamil Nadu. The Supreme Court reiterated the right of strike, and it held that the right to strike is not fundamental right, it is not a constitutional right, it is not a legal right, it is not a moral right of government employees and workers working in a public utility services. So this is a very landmark decision by Supreme Court of India. But even though this is not the constitutional right, moral right, fundamental right, etc., but the Industrial Dispute Act 1947, it allows workmen or the employees to go on a strike only by following certain conditions, terms and conditions, and these terms and conditions are provided in section 22, 23 and 24 of the act. There is a clerical mistake, you can see there section 34, but it is not 34, actually it is 24. So these conditions are provided. Section 22, section 23 and 24 of the Industrial Dispute Act provides the conditions and circumstances which decides the legality or illegality of strike. So we must see what are those conditions which are mentioned under section 22 and 23 in this lecture. So friends, firstly we are going to discuss section 22 of the act, and which works as a special prohibition of strike and lockout in public utility services. So if the workmen are working in a public utility services, they are prohibited from going on lockout, and this prohibition is provided by section 22 of the act. We must see. So before going to discuss what is the prohibition under this section, we must know what is the concept of public utility services. So in general, public utility services means all those services which are declared as a public utility services, because these services are essential for the daily livelihood of public at large. Friends, these services include banking, electricity, post, gas, transportation and a railway, etc. Again, the act has given power to appropriate government to declare any services as a public utility services. So we must see what is the definition of public utility services. Section 2N of the act defines what is public utility services, and according to this definition, The following are the public utility services. If you go through the definition, you can find this definition is an inclusive definition. It just includes certain examples of services that are declared by government as public utility services. Like these public utility services include any railway services, any transport services for carriage of passengers and goods, or the airs, passenger through air. So whatever the carrying of passengers and goods, whether on land or in air, all these services are called as public utility services. Then it includes any postal services, telegraph services, and telephone services. These are also declared as public utility services. Then it includes any industry which supply light, water to public, because this is also necessary service in daily livelihood. Then this definition includes any system of public conservancy or the sanitation, because as we know, we what is the importance of sanitation in the urbanization, etc. Therefore the sanitation services are also included into the definition of public utility services. Then it includes any industry which is specified in the first schedule, and we must know that government has power to include or exclude any services in this schedule. So whatever the services that are included into the first schedule of Industrial Dispute Act, these services are called as public utility services. So friends, in brief, these services are nothing but the services of importance in public life, which are necessary for daily livelihood. Now friends, we are going to discuss what is the prohibition of strike and lockout in public utility services. Section 22 clause 1 of the act specifically prohibits strike in public utility service. Prohibition means they are prohibited from going on strike. See friends, the section 22 clause 1 prohibits the strike, and according to this section, no person employed in public utility services shall go on a strike in following circumstances. Number 1, he shall not go on a strike without giving notice to employer before 6 weeks of actual notice. So it is responsibility of workers, if they want to go on a strike on a particular date, so from that date, prior to 6 weeks of that date, the workman should give notice to employer. Or the second condition is that the workman cannot go on a strike within 14 days of giving of such notice. So first thing is the prior notice should be given, and that should be the prior to 6 weeks of actual strike. Or second condition is that when such notice is given, then that workman cannot go on a strike within 14 days of such notice, because this is the time period which is provided to employer to take necessary steps to avoid the strike or to prevent the strike. Or third condition is that, and see, all are alternative to each other, all are not the compulsory. Say third condition is that the workers cannot go on a strike before expiry date of strike as mentioned in above notice. What the earlier notice given in a first condition, if the employees has given 6 weeks prior notice, and in that notice if the date of strike is mentioned, then workman cannot go on a strike before expiry of that date, whatever the date that is mentioned in that notice. Then the workmen cannot go on a strike during the pendency of any conciliation proceedings and 7 days after conciliation conclusion of such proceedings. See, we have discussed different authorities under Industrial Dispute Act, and the conciliation is one of the authority, conciliation officer as well as the board of conciliation. So where any proceedings, any dispute is there, and when such dispute is referred to such conciliation officer and board of conciliation for the cancellation proceedings. So during the pendency of that period, the workers cannot go on a strike, and when that proceedings are concluded from the conclusion date and next 7 days, they cannot go on a strike. So this is the specific period which is provided to employer to prevent the possible strike and lockout. So it is to be noted that these provisions do not prohibit the workman from going on a strike, but this provision requires him to fulfill certain conditions before going on a strike. So they cannot go on a strike by violating these conditions. Now this was relating to prohibition of strike. Now section 22 clause 2, it prohibits the lockout. Here I have written section 22 clause 1, but it is actually clause 2. See, the employer, if he wants to go on a strike, he has to follow what the conditions that are given under section 22 clause 2. So the employer carrying public utility services shall not go on a strike in following circumstances or without following conditions. First one is, he cannot commence the strike lockout without giving the notice of lockout to employees prior to 6 weeks of actual lockout. He must give the prior notice. Secondly, without giving of such notice, the employees, this is the first thing. Then second is, if the employer has given any 6 weeks prior notice to employees on in and from that date, the employer cannot commence the lockout within 14 days of such notice. This is the second criteria. Then third criteria is that employer cannot commence the lockout before expiry of date of lockout, which is mentioned in a above notice. Then fourth is, the employer cannot commence the lockout during the pendency of any conciliation proceedings and 7 days after conclusion of such proceedings. So if you go through these two clauses, section 22 clause 1 and section 22 clause 2, we can find the similar obligations are imposed upon workers as well as employer before commencing strike or lockout in public utility services. So in both sections we have discussed that particular notice has to be given. So this is the special prohibition. Section 22 of the act provides that the notice of strike that shall be given, that must be in a writing, and that must be in a prescribed form. So regarding that, there is case law in Tata Iron Steel Company versus Workman. That case is decided in 1972, where the court held that the notice that should be given under section 22, it is mandatory for valid strike and lockout. So this is special provision for prohibiting strike and lockout in public utility services. So as this section 22 clause 4 and 5 specifically requires the form of notice that to be given for valid strike and lockout. Friends, now we are going to discuss the general prohibition of strike and lockout that is provided by section 23 of the act. See, as you know, what the prohibition that was made under section 22, that was applicable to public utility services only, but this section 23 of the act, it provides general prohibition of strike and lockout. So it is applicable to both kind of industries, whether these industries are public utility services or not. So This is applicable to both the industries, public utility services as well as the general industries also, other industries also. Now we must see what is the prohibition, general prohibition that is provided by section 23 of the act. So according to section 23, a strike and lockout in breach of contract by workman or the employee is specifically prohibited in following cases. It means not the employees can commence the strike, nor the employer can lock out the industry in a following cases. So we must know what are those cases. The first is the employer cannot commence the lockout, or employees cannot go on a strike during the pendency of conciliation proceedings before the board and 7 days after conclusion of proceedings. This is very important because this is necessary to ensure proper conciliation proceedings before the court, and that should not be hampered by the strike and lockout, etc. Then second condition, where the employer and employee cannot go on a lockout or strike, is they cannot commence the strike or lockout during the arbitration proceedings before the arbitrator and 2 months after conclusion of such proceedings. See, actually Industrial Dispute Act provides one of the mode through which industrial dispute can be settled, and that mode is arbitration. Parties can voluntarily refer their dispute to the arbitration authority, and then whatever the decision that is given by arbitration authority will be binding on parties. Therefore, to ensure proper arbitration proceedings before the authority, this strike during that period is specifically prohibited by the Industrial Dispute Act. Then third condition in which they cannot go on a strike or employer cannot commence the lockout is during the pendency of proceedings before labor court and other authorities and 2 months after conclusion of such things. So as we know, the Industrial Dispute Act provides adjudication authorities also. So when appropriate government refers such dispute at adjudication authority, there should be proper adjudication, and adjudication without any kind of influence. So to ensure the proper adjudication, this period is prohibited for the commencement of strike as well as a lockout. So these are the circumstances where they cannot go on a strike or lockout. And lastly, the employer cannot commence the lockout, or workers cannot go on a strike during the period of settlement of an award or the operation of award. So these are the prohibitions, and basically this section ensures though this is not the circumstance, but basically this section ensures the proper peaceful atmosphere to enable proper conciliation, arbitration and adjudication before appropriate authority under the act. So friends, this is how we have discussed the first part of the strike, when it strike and lockout when it becomes illegal. So section 22 and section 23 of the act provides the circumstances where the dispute cannot be commenced, lockout cannot be commenced, and if any strike and lockout is declared without violating what the prohibition that is provided by section 22 or what the prohibition that is provided by 23, that strike can be called as a legal. So friends, in next lecture we are going to discuss which are those circumstances where strike or lockout becomes illegal. So friends, if you can like this video, you can share it with your friends, and do not forget to subscribe my channel. So friends, thank you.